There are a few ways in which children can become US citizens. One of the ways is called CRBA, a Consular Report of Birth Abroad. So a child, for example, who is born outside the United States to one US citizen parent and, for example, one non-US citizen parent, that child may be entitled to US citizenship providing that the US citizen parent had been physically present in the United States or one of its outlying possessions for 5 years. At least 2 years must be after that US citizen parent reached the age of 14 years old. So the period of physical presence must be for at least 5 years, and it must have taken place before the birth of the child. So if you're a foreign national, you came into the US in the year 2000, you became a US citizen, you lived here all the way through to 2010, and then you have a baby outside the US. So long as your physical presence has 5 years in the United States before the birth of the child, then your child may become a US citizen under the CRBA process. Right now, the other method would be through the INA, Immigration and Nationality Act, Section 322. That's children who don't qualify to get Certificate of Citizenship or a Consular Report of Birth Abroad. They can apply for citizenship under the INA 322. And that is for if a parent who's a US citizen, or if the parent is dead within the last 5 years, a US citizen grandparent can file that application on behalf of the child. The child in this situation is also born outside the United States, and that child regularly resides outside the United States. Now, where children do not qualify or they're not eligible for CRBA because their parents or the US citizen parent through whom they are trying to get citizenship did not have 5 years of physical presence in the US, then they could resort to this INA 322 type of citizenship. Okay, now the child must be somebody who regularly resides or lives outside the United States, and they are eligible for US citizenship if some conditions have been met. The first one is that the person must be a child of a parent who's a US citizen either by birth or through naturalization, right? So the US citizen parents must have obtained their citizenship through birth or naturalization. And then number two, the child's US citizen parent or citizen grandparent, they must meet certain physical presence requirements in the United States or an outlying possession. Under this method, again, you can either as a child qualify for US citizenship through your parent or through your grandparent. Okay? And the child again must be under the age of 18 years old. The child must reside outside the US, as I mentioned, in the legal and physical custody of the US citizen parent or of a person who does not object to the application if the US citizen parent is dead or deceased. And then the child is lawfully admitted. That is, the child must be physically present and maintaining a lawful status in the United States at the time the application is approved and the time of naturalization, meaning the child has to be here to take their oath of citizenship. Now, there's a difference between CRBA and trying to apply for US citizenship under INA Section 322 or under INA Section 320. If your child is eligible for CRBA, it means that, the US citizen parents meet the physical presence requirement of 5 years before the child was born. If the US citizen parent is short of that time frame and the child regularly resides outside and qualifies under INA 322, as I've mentioned, then the child can apply using the N600k process. Now, if the child, on the other hand, the US citizen parent was unable to meet the 5 years of physical presence after the birth of the child and does an I-130 petition and allows the child to immigrate as a lawful permanent resident into the US or to the United States, then the child can acquire US citizenship automatically once they're admitted pursuant to their lawful permanent residency, and then they reside in the US in the legal and physical custody of the US citizen parent. Okay, so there's the CRBA method where you have to show the US citizen parent has to show 5 years of physical presence before the birth of the child in the United States. 2 of those years must be after the age of 14 years, or we can do the N600k where the child regularly resides outside the US and acquired US citizenship, or the N600 where the child has been admitted into the United States pursuant to lawful permanent residency. Okay, so if you need help with any of these processes, you're confused, just need assistance with these or with any other US immigration case, we're here to help you. 802-780-0564. Can't wait to speak with you. Bye.